Hello all, welcome. Today we will be covering ERISA fiduciary duty claims relating to the inclusion of employer stock in retirement plans. As part of this video, we will cover the audio recording of the case and also cover the decision by the court at the end. Hensley and other participants in Fluor Corporation's retirement plan allege that plan fiduciaries breached their duties under ERISA by continuing to offer Fluor Company stock as an investment option when they knew or should have known the stock was overvalued due to undisclosed problems at the company. The case implicates the Supreme Court's precedent in Fifth Third Bancorp v. Dudenhoeffer, which established a special pleading standard for claims challenging fiduciary decisions about employer stock in retirement plans. The central legal question involves the application of the Dudenhoeffer standard and what plaintiffs must allege to state a plausible claim that ERISA fiduciaries breached their duties by failing to act on inside information about the value of employer stock. Following is the audio recording of the actual court hearing.
Argument next in Case 24-924, Hensley v. Fluor Corporation. Mr. Chang.
Mr. Chief Justice, and may it please the Court. After the Army found that Fluor's disregard of key contractual requirements led to the bombing at Bagram, Specialist Hensley tried to seek some measure of justice. But the Fourth Circuit blocked his efforts on a rationale that Fluor doesn't defend. Fluor's alternative theories do not justify preemption here either. First, Fluor argues that the Constitution structure, either by itself or through its emanations of federal interests, preempts Hensley's claims. That argument has no basis in the Constitution's text, structure, and history. Our Constitution presumes that state tort claims are available and leaves it to Congress to alter that default rule. Congress has done so in some circumstances when it comes to federal contractors, but it has not barred claims by American soldiers injured by contractor negligence. Second, Fluor seeks to radically expand Boyle. Boyle is a basis for reversing and not affirming the judgment. Boyle recognized a limited defense for contractors who do what the government says. Boyle doesn't apply here because the Army itself found that Fluor violated the Army's instructions. Fluor's contrary reading of Boyle contradicts Boyle itself, and it cannot be harmonized with the warning in Rodriguez that judicial lawmaking should play a modest role, or the teaching in Garcia that preemption cannot be based on uncodified interests. I welcome the Court's questions.
Did respondent make the constitutional arguments below?
I believe it was included in a small portion of their appellee's brief below, Your Honor.
Does it, in your case, is there any portion of activity that we're talking about that was done at the direction of the military that's involved here?
We don't think so, Your Honor. And the reason is supervision and escorting were left entirely to Fluor under the contract. Once the bomber was hired and was on the base, it was up to Fluor under its contractual obligations to supervise him at his work site as well as to escort him.
And would you spend just a brief moment discussing why Boyle is not dispositive or why it doesn't control here?
Sure. So Boyle is all about a contractor who does what the government says. That is the heart and soul of Boyle. It starts at page 505 by saying the government's interest is in getting its work done. And at step 2, it says there was a significant conflict between state tort duty and what the government required that was precisely contrary to what the government required. And at step 3, Boyle made it very clear that its defense is for contractors who adhere to the government's specifications.
What do you do with the entire text and history of the Constitution, which says war fighting in combat zones is a federal interest, and the states, Article 1, Section 10, and otherwise, have nothing to do with how America conducts its operations in a combat zone?
Certainly, Your Honor. So Articles 1 and 2 do not automatically preempt state law when it comes to federal contractors. And we know that from cases like Penn-Dairies and North Dakota. In Penn-Dairies, this court said there is no clause of the Constitution which purports, unaided by congressional enactment, to prohibit such regulations, and such regulations there was regulations of military contractors. And of course, Justice Kavanaugh.
Well, in a war zone, though, in a combat zone, we have a line of cases, Garamendi, Crosby, you know all the cases, put aside Boyle. Boyle footnote 4 talks about this, but not Boyle, the rest of it, that says that there are certain areas where there's a uniquely federal interest. And in those areas, the usual preemption rules don't apply, that we expect Congress actually to speak clearly if they want to provide for something like state tort suits. And that's flipped. And it would think if you're talking about uniquely federal interests, there's nothing that's more uniquely federal than successfully fighting a war in a combat zone.
Certainly, Your Honor, we agree that Texas can't declare war in Mexico or New York can't invade Canada.
But can Texas regulate how the military structures its operations at Bagram, or can South Carolina regulate it? And that raises another question here, which is pointed out by Judge Silberman in his opinion on this, which you're familiar with, which is, can 50 different jurisdictions regulate what's going on at Bagram?
Certainly, I'll address in turn. So as to the constitutional structural point, we know the default is common law claims are available. And it goes all the way back to cases like Little v. Barry, where Chief Justice Marshall, he upheld damages award against the Navy captain who was following the president's order. And also in cases like Mitchell versus Harmony, there was a common law claim against an Army colonel who seized an American citizen's property during the Mexican-American War in that case. So we do know this is certainly an area where Congress can certainly act, and Congress has done so.
Well, I agree with that, so I don't want this to sound like I disagree with that. Congress can certainly act. The question is, what's the baseline?
So the baseline...
And the baseline, I thought, under our case law going back, way back, if it's a uniquely federal interest, we have lots of cases saying something along those lines, that we require Congress to act to allow such suits. And we've said in, Crosby, for example, a failure to provide for preemption expressly may reflect nothing more than the settled character of implied preemption doctrine that courts will dependably apply. And so Congress looking at this area, the idea that state tort law is going to regulate what goes on in Bagram, I think Congress will be like, sounds way out there, and not something that they need to get involved in because of the doctrine, as Crosby says, that is dependably applied.
Sure. So 2 responses, Your Honor. The first is the fact that military contractors might face some liability for acts occurring overseas U.S. bases was not lost on Congress. So Congress in 1941 passed a law called Defense Base Act. And what Congress did there was to exclude or preclude liability for government contractors occurring on U.S. bases as to their civilian employees that are under their supervision. So what that says is the fact that, Congress, of course, operating against a background law like Little and Mitchell, knew that common law had a reach, even on foreign soil. And Congress certainly could have acted to take that back as to when it comes to American soldier who is injured by contractors.
Counsel, isn't the simple answer to Judge Kavanaugh is the 50 states can't tell the military what to do, correct?
Certainly. Absolutely correct, Your Honor.
They don't have – we've already said that in Boyle.
Correct.
And we made it clear. If the military orders them to do something, they have to do it.
Correct.
They're
military contractors, though.
The military contractor. So what Justice Kavanaugh is talking about is almost a field preemption concept.
Yeah.
That absent the conflict, an entire field is preempted. And what you're saying, I think, by using Little and Mitchell, is that entire field in our history has not been considered preempted, correct?
That is correct, Your Honor.
All right. So now let's go down to something more, I think. The interest that's being protected is military interest, correct?
Yes.
All right. It's the federal government's military interest.
Correct.
You only get liability if the state law conflicts with military orders in some way.
Correct.
And so if there's no conflict, there's no interest to protect, correct?
There's nothing here because Fluor violated what the military wanted it to do.
that's the question that Justice Thomas asked you, which is there has been no directive by the state that the contractor had to do X, Y, and Z. It was a directive of the military, correct?
Correct, Your Honor. I mean, so we think that the state law duty also applies here, the duty of reasonable supervision.
It does because the government didn't direct unreasonable conduct.
Correct.
If the government directed unreasonable conduct, there'd be no liability, correct?
Correct. The government did not direct Fluor to disregard supervision duties.
Mr. Chang.
We'd be creating a new area of preemption law if we say that there is field preemption.
Especially through
when
federal
there
interests.
is no conflict whatsoever.
Well, footnote 11 of Garamendi says if a state were simply to take a position on a matter of foreign policy with no serious claim to be addressing a traditional state responsibility, field preemption might be the appropriate doctrine. I mean, there's been a lot of discussion in the case law about how you distinguish field and conflict, but, field preemption in an area of uniquely federal interest, you can call it conflict, you can call it field, but the word field has been in our case law at times on this kind of thing. I'll stop there, but I just want to get that comment out.
And I guess I want to ask, following up about the field, it seems to me you don't necessarily lose even under the enclave theory, because I understand the field preemption argument to be kind of a Clearfield Trust, Kimball Foods. This is an enclave of uniquely federal interest, but even if that's so, all of that means, and Boyle kind of finesses this question, but all that means is that the federal court would adopt a common law rule. It doesn't necessarily mean that the state rule would be that there would be no liability, I guess is what I'm saying. So if that were the case, we would still have to decide what the rule would be, and we could decide to let state law apply as a matter of federal common law, right? And if we look at the Federal Tort Claims Act and you see that the combat activities exception doesn't extend to independent contractors, you might say, well, it makes sense to allow liability to remain even if we're doing it as a matter of federal common law, right?
That is certainly correct, Your Honor. So there is a line of cases that say as a matter of federal common law rule, we're going to adopt the state law rule here. But I think the simplest way here is to just read Boyle as it is, and it's about a contractor who does what the government
No.
does.
I understand that. I guess what I'm saying is I think you could win even if even if we're looking at it as a matter of, listen, the Constitution carves out war powers and that sort of thing as an enclave of uniquely federal interest, which it does, right? If you took that line of analysis, I don't think you necessarily lose even under that line of analysis.
We wouldn't, Your Honor.
Do you understand Boyle then? Sorry, can I just finish?
Yeah, sure.
Do you understand Boyle then to create a very narrow kind of preemption that's not constitutional, that really is just about the conflict of contract terms?
Yes, that's how we understand it. And that's what the opinion in Boyle said as well, because Boyle carves out two hypotheticals where you're dealing with the government contract.
Yeah.
Correct. And a stock helicopter example as well. So that clearly shows that contractors, or Justice Scalia envisioned a system where contractors are still subject to state law liability.
Well, Mr. Chang, you're backtracking a lot from the position that I took when I read that I took from your brief. Basically, the thrust of your brief is Boyle is inconsistent with textualism. The whole idea of uniquely federal interest preemption is wrong. I'm quoting you, Boyle's uniquely federal interest preemption is difficult to reconcile with the supremacy clause in this court's preemption cases. Brooding federal interests and judicial policy inquiries cannot support preemption, yet Boyle invites precisely those types of those inquiries. So you can't quite bring yourself to say Boyle's inconsistent with textualism and it should be overruled. But what I got from your brief was you want us to, limit it as much as possible. Did I read too much into your brief?
No. So our position is that this court does not have to overrule Boyle because we win even under Boyle's terms. And certainly the only reason that
was Boyle correctly decided? Suppose it was before us today. What would you say?
I would follow what you wrote in Garcia, Your Honor, that the supremacy clause is limited to the Constitution, federal statutes, and treaties.
Well, I don't think that's quite what I wrote, but
even if you didn't,
that's something else. I mean, what I took from your brief is you're saying Boyle's inconsistent with textualism. Who wrote Boyle?
Justice Scalia wrote it.
So you're saying the founding father of textualism doesn't understand textualism?
No, that's not what I'm saying at all.
Well,
Your
that's
Honor.
what I thought. Well, are you willing to? Are there situations in which the supremacy clause itself has a preemptive effect?
This court has understood it so. As this court said in United States versus Washington, there are circumstances where the state law directly regulates the federal government, or it discriminates against the federal government or its contractors.
So why wouldn't that apply when what is at issue are actions taken by a military contractor basically on the battlefield, and you want state courts and state juries to decide whether what the military contractor did is justified?
No, Your Honor, first, we're dealing with something that occurred on the civilian part of the base involving
it's
Bagram.
It's a beleaguered.
Come on.
It's a military base in a war zone. And the very fact that there was this terrorist attack there shows the connection with the conduct of the war, doesn't it?
So we're dealing with something that the Army left entirely to Fluor to do. And this is a natural consequence of the fact that Congress knew about contractor liability, but has not limited service members to be able to sue contractors when they're injured.
Now, suppose a contract says that the contractor is to provide appropriate protection when it is accompanying a convoy through a dangerous area. All right, would it claim, and let's say that a member of the military is injured, could that member of the military sue the contractor on the theory that the contractor was negligent?
It depends on what the Army's understanding was, and Boyle contemplates this too, Your Honor. So Boyle says you look first at whether there was a reasonably precise specification, and the step two is whether or not the contractor adhered to that standard.
What if it's just provide appropriate protection?
I think Boyle contemplates litigation over that issue.
Serious?
I was thinking of a similar question to Justice Alito, that you could have the rule that you're suggesting here, and it's the rule that I do think follows from Boyle, which is that the contractor is liable as long as the military didn't specifically approve or direct the conduct. But you could have a more deferential rule, which still allows some forms of state liability to come in, which is that the contractor is liable if but only if the plaintiff can show that the contractor violated military policy. In other words, so in this set of circumstances of the kind that Justice Alito was given, where the government doesn't really say one way or the other, maybe doesn't say anything at all, or maybe leaves it to the contractor to decide, their liability would not be all right. Instead, liability could come into effect only if you could show that the contractor violated military policy. What would you think of a rule like that?
We would certainly be okay with that rule. Certainly, if the court is already thinking about creating some sort of a federal common law rule in this area, we think it should be the one that furthers the government's interests by avoiding contractor negligence and incentivizes contractor adherence in a war zone. And this ended up injuring multiple U.S. soldiers on the base because Fluor didn't do what the Army told it to do. So if we're thinking about what kind of rule applies, the rule has to be one that saves soldiers.
Mr. Chang, as a matter of conflict of laws, why does South Carolina law even apply? And I understand we don't have to decide that question to decide this case, but it does seem perplexing.
Certainly. So part of it is it's largely a choice of Fluor's. Fluor was the one who put a principal place of business in South Carolina. It should be not surprising at all sometimes when you apply choice of law principles that the forum state's law might apply to you. And here, Fluor hasn't disputed our assertion that South Carolina law controls.
Is it possible that Afghan law could apply based on choice of law principles?
It's certainly possible, Your Honor.
So it's possible that a suit against a military contractor in a war zone could be based on the enemy's law.
Which seems bizarre. If this happened on an American base, I wouldn't understand the base to be Afghan soil. I would understand it to be U.S. soil. So if that – seriously?
Certainly. I mean, there are some courts that have – lower courts that have applied Afghan law in situations like this. However, there are certainly other things that factor in as well, like, whether there's an agreement with between
Doesn't
the
that
US
seem like a
government.
pretty big problem for your theory, if that's the state law, if the default is whatever law would otherwise apply, as Justice Kavanaugh is saying, the enemy's law is going to apply to that suggests that maybe a federal common law should apply, maybe not the common law rule that Fluor and the government won, but if the alternative is a default of Afghan law?
So two responses to that, Your Honor. The first is that so when it comes to applying foreign law to judge the acts of a military contractor, again, that's an ordinary working of the fact that Congress has not displaced state law, which includes the operation of choice of law principles under that state law. And the second is that, this is obviously not an issue in this case because we're solely talking about preemption here and Fluor hasn't raised any choice of law issues. But there might be other doctrines that preclude the application of foreign law in situations like this.
Can I circle back to something Justice Alito asked? He asked you what the scope of if you thought there was constitutional preemption as a principle. And you said yes, I believe, but correct me if I'm wrong. And I wanted to know, is uniquely federal interest a branch of constitutional preemption in your view?
We believe it's a branch of federal common law preemption, Your Honor. So
what's the difference then between what you're calling constitutional preemption and federal common law preemption as to the concept of uniquely federal interest, or is there any difference at all?
So what I was talking to Justice Alito about was cases like U.S. v. Washington and Penn-Dairies and North Dakota.
Can you just answer my question? Is there any difference?
There is a difference, Your Honor.
What is the difference?
The difference is one comes from the structure of the Constitution and this Court's decisions.
Difference in application. Is there any difference in application? I'm sorry.
Yes, Your Honor, because one is saying that states cannot act in a discriminatory manner against a contractor, and the other is that you're displacing the operation of the entire state law from that area. So when it comes
unless Congress specifies otherwise, always important to put that on there. Congress could provide for state tort law in this area. That's my point, which is this whole case, in my view, starts with what's your baseline? State tort law regulating military contractors in a war zone. Is your baseline that Congress has to speak to displace that, or that Congress has to speak to provide for that? And I would think our uniquely federal interest branch of preemption law makes, I thought, fairly clear that Congress would have to speak to provide for that. And look, what happened here is terrible, so I'm completely sympathetic to that. But in terms of the legal framework that applies for situations like this, my thought, based on the precedent, was Congress has to speak to provide for it.
We don't think so, Your Honor. Given cases like Little and Mitchell, we think the default is that common law rule is in place unless Congress affirmatively displaces the operation of the state
And is it
law.
your view that Boyle comes out differently under Justice Kavanaugh's theory? I guess I'm trying to understand that if we sweep as broadly as this is a war zone and there's a uniquely federal interest, I thought that was also the case, not maybe the war zone part, but the uniquely federal interest part in Boyle. So doesn't it come out differently?
Your Honor, there is certainly a tension.
Or at least we don't need all the analysis that Boyle has to get to preemption, I guess. If we could just say at step one, uniquely federal interest, and that's the end of it, right?
That is not even the analysis in Boyle. Boyle, uniquely federal interest, was the starting point in Boyle.
Correct. So there was more to it, and there was a reason because the understanding was that there still might be an opportunity or a circumstance in which you would have liability, even though we're talking about a federal government contractor dealing with the procurement of military equipment in a way that is obviously implicating federal interests.
That's certainly right, Your Honor.
So can you just say a little bit about the Padilla test? As I read your brief, in the last few pages, you seemed to say that if the court applies the kind of Boyle analysis here, it's the Padilla test that you would suggest. Why is that?
So we think that the Padilla test is more faithful to what this Court's teaching in Boyle. Again, Boyle zeroed in on the federal government's interest in getting its work done and making sure that there wasn't a conflict between that decision and the state law duty. So Padilla looks close to that, and if we get to that, because Padilla actually looks at what the military has authorized and directed. So it is a test that closely tracks the military's decision and Boyle.
If preemption depends on the interpretation of the contract and whether the contractor violated the terms of the contract, do you want us to adopt something like the rule that used to apply in foreign sovereign immunities cases, so that if the government says there was no violation of the contract, that's the end of the matter? Or would you say no, the plaintiff still has the opportunity to litigate that issue in state court, presumably, possibly in front of a jury?
We don't have a strong position on that, Your Honor. Certainly, if the court says what the military says is preclusive, that's good for us because the military favored us in this case.
Well, not that it would be preclusive against Fluor. Would it be preclusive against you on the issue of preemption?
Like I said, we don't have a position one way or another on that.
How can you not have a position on that? That seems to me quite critical to what's at stake here.
Certainly, Boyle, as step one, leaves that possibility open in this area. It anticipates litigation over what the specification meant and whether there was a compliance with that specification. It would be a really hard case for any plaintiff to disagree with an Army coming in. And even if a judge disagrees with that, that would give the contractor a great reason on appeal. And that is not a reason to displace state law.
Thank you, counsel. I'm sorry. Justice Thomas, further?
As I understand your argument, you're not saying that the government is precluded from preempting the lawsuit, your lawsuit.
Correct, Your Honor.
Would you walk me through the argument for the Federal Tort Claim Act, a Federal Tort Claim Act exception operating as a preemption statute?
So obviously we don't believe that it does, Your Honor. And that argument has sort of fallen to the wayside during the merits briefing here because Fluor is now relying on a completely different source of federal interest in this case. As I understood it, it was that, as the Fourth Circuit said, the combatant activities exception has a policy of protecting the military's judgment, and that meant that even the imposition per se of state law was a problematic imposition.
Justice Alito? Justice Sotomayor?
No.
Ms. Kagan? Justice Gorsuch?
Just if states wanted to do this not by tort law, but wanted to do it by regulatory law, they could do that, I assume, as well, correct?
But it would be limited. Its ability to do that would be severely limited.
Tell me what the limits are.
The limits are the non-discrimination principle that we discussed. And also, we certainly do not argue that there is
general state regulation of workplace safety. That would be non-discriminatory, right?
That would be non-discriminatory, but again, that might conflict with the provision.
Employee rights. That would be non-discriminatory, right?
It's not clear if that would include a soldier overseas, and also
it's a contractor.
To a contractor,
a military contractor overseas. The state wants to apply its employee rules, its workplace safety rules on a non-discriminatory basis. Yes or no?
No, because the DBA already precludes things like that.
What kinds of regulatory? But you said some could be applied, right?
If it was like a safety regulation, like here, that could certainly be it.
What do you say to the retired military brief that says that this is going to, your rule would lead to finger pointing, which I think this suit would lead to finger pointing by the defendant against the military, and back and forth on that? You know, how does someone who used to be in the Taliban end up running a 5K or whatever it was at the starting line? That's going to be a lot of finger pointing on that. And the retired military officers say in military theaters, legal uncertainty and finger pointing are an invitation to ruin. And I'm just curious your response to that.
So this is a situation where the military already found that it was not responsible. It was Fluor's responsibility.
Well, the military found that, right?
Oh, certainly. I mean, so there might be finger pointing, but
certainly Fluor's not going to agree with that, right?
And at the end of the day, if there's just a possibility of things that might unfold during discovery or evidentiary issues.
What do you imagine in state court, like generals, military officers coming in for testimony about what our rules were for the people who worked in the vehicle yard, what our rules were for who could run in the 5K, why we had former Taliban working on a U.S. base at Bagram? That'd be an interesting discussion, I'm sure. Do you envision that kind of testimony happening in the state court?
No, not at all. Because here the Fourth Circuit already agreed with us that the litigation here would not lead to assigning fault to the military. We can assume military made decisions that it made, and we can judge Fluor's actions under those military decisions as a given. We can take that as a given.
Have any federal courts gone your way on this general issue so far?
So the Padilla court has agreed with us, and that's why there was a circuit split in this case.
Okay, thank you.
Justice Barrett?
Just to follow up quickly on Justice Kavanaugh's question about the finger pointing and the kinds of questions that the United States would be asked, it's my understanding in the United States brief that it said that it could assert the state secrets privilege and reserve the right to do so, although it had not yet in this case, right?
That's correct.
So if there was confidential information, there would be, you would agree, some sort of protection.
100%. And the reason why, and the fact that there are other mechanisms to protect the government's interests like that, undercuts the need to displace state law with federal common law in this case.
Justice Jackson?
And is it your view that really the rule that you want us to adopt, or the one that you're focused on, is applicable in the situation in which the contractor acts contrary to the military's interests because it's doing something negligently, that it has not been authorized by the military to behave in this way, the particular way that is being claimed as causing the injury in this case?
That's correct. I mean, if we're creating a federal rule to further the government's interests, the violations have to be factored in too.
How do we think about the fact that apparently DOD and its regulations left open the opportunity or said to contractors that you could be held liable? So it's the government's understanding that there's some operation of common law potentially against contractors in this universe, right?
That's huge, Your Honor. I mean, the fact that DOD has been telling contractors that they could be liable and that the public policy rationale of Boyle will not protect you if the government's decisions are not at issue, that's huge. And we also have the fact that Congress has not acted to displace state law here.
And with respect to the FTCA and the combatant activities, in your exchange with Justice Thomas, I guess I'm also curious about the point that I think Justice Barrett made earlier, which is that the combatant activities exception doesn't apply to contractors, correct?
Not at all.
So Congress did not envision a world necessarily in which contractors would not be held liable for these kinds of things.
Not at all. And that Congress doubled down in the Westfall Act when it passed Westfall Act to protect federal officials from lawsuits. It adopted the definition of the FTCA, which is the same, excluding contractors.
And finally, let's say if we think Padilla is the correct test, should we vacate and remand for further proceedings under that test? That was not what was applied here, correct?
No, but you should not there's no need to, Your Honor, because we made arguments about why our position is correct under the Padilla test. It has not been disputed that Fluor could somehow meet that test here. And that is not the case because they violated whatever the military authorized and directed in this case.
Thank you.
Thank you, counsel. Mr. Mosier?
Mr. Chief Justice, and may it please the Court, this case arises out of an enemy attack on U.S. military forces on a foreign battlefield in time of war. Petitioner sued Fluor under South Carolina tort law for failing to prevent that act of war. Those state law claims are preempted because they conflict with uniquely federal interests. Petitioner's claims interfere with the federal government's exclusive war-making powers. The Constitution vests all war powers in the federal government and expressly withdraws from the states the power to engage in war. applying tort law on a foreign battlefield would hinder the federal government.
That concludes the audio recording of the court proceedings. As of this recording, the Supreme Court has not yet issued its decision in this case. The case was argued during the October 2025 term, and a decision is expected by late June 2026. When the decision is released, we will update this presentation with the court's ruling, the vote breakdown, and the reasoning of the majority and any concurring or dissenting opinions. In the meantime, we encourage you to follow the case and consider the legal arguments presented by both sides. The outcome could have significant implications for the areas of law discussed in the introduction. This concludes this presentation. If you have thoughts on this case, do comment below the video. Also, to receive notifications of future cases, be sure to subscribe to the channel. Please share the channel link with your friends and peers that you think may be interested in or benefit from it. Thank you.